Dear colleagues, dear friends, I am happy to welcome you at our interview project Modern Arbitration Live that is supported by Russian Arbitration Center and Legal Forum Academy. Within this project we discuss with the leading Russian and foreign lawyers the most interesting practical issues of dispute resolution. And today we have a very special guest, Mr. Gari Born. Thank you, Garri, for coming to Moscow and for coming here to us.
Thank you.
On the one hand, as you are one of the most famous international arbitration litigation practitioners, there is no need to introduce you to the audience. But on the other hand, Legal Forum Academy has such a broad audience in Russia and CIS that I'm sure that our interview will be watched by people who don't know much about arbitration, but who want to know more about arbitration. So let me please first introduce you to the audience.
By all means.
Garri Born is the chair of the International Arbitration Practice Group in Wilmer Cutler, Pickering, Hale and Dorr LLP law firm. He is also the president of Singapore International Arbitration SIC Court of Arbitration. Mr. Born has served as counsel in more than 675 arbitrations, including the largest ICC and ad hoc arbitration in the history, and also has sat as arbitrator in more than 250 ad hoc and institutional arbitrators. Mr. Garri Born has a lot of awards, including Best Lawyer in the Sphere of International Arbitration by Best Lawyers London, and a lot of other awards. And also, Mr. Garri Born has published a number of leading works on international arbitration and other dispute resolution forms. The most famous books include International Commercial Arbitration, International Arbitration Law and Practice, and also International Arbitration Forum Selection Agreements, Drafting and Enforcing. Mr. Born is also the honorary professor of St. Gallen University, Switzerland, Tsinghua University, Beijing, and regularly teaches in leading institutions all over the world, such as Harvard, Stanford, National University of Singapore, and elsewhere. I know that during your stay in Moscow, you have lectures in the leading Moscow universities, such as High School of Economics and Moscow State University, and I think that's really a great chance for the Moscow Russian students that I could only dream of when I was a student. Thank you very much for this. But as I also usually say that now sometimes students know about international arbitration here in Russia more than practitioners, elder generation. So that's why, following the arbitration reform and growing interest in arbitration, we are doing a lot of work here to promote modern, good, faithful arbitration. And we speak not only about Moscow, but only about other cities. And me personally, I travel a lot and do lectures, seminars, and I need to explain the advantages of arbitration, sometimes the nature of arbitration. So what, in your opinion, my first question would be the most appealing advantages of arbitration comparing to litigation, both for domestic and international disputes, because domestic disputes are also important here.
Sure. That's a great question. And before I answer it, let me say thank you. Thank you for the opportunity to speak here today. Thank you also for the very flattering, overly flattering introduction. I appreciate that as well. Why is it that parties in both domestic and international cases choose very frequently to resolve their disputes by arbitration? I think there are two main sets of reasons. One you might describe as pragmatic or practical. I think of those reasons as, at least in English, the 5 E's. Arbitration is more efficient, more expeditious, more expert, more even-handed, and more enforceable. 5 reasons that commercial parties, also states increasingly, prefer to use arbitration to resolve both domestic and also, very importantly, international, commercial, and other disputes. Arbitration is more efficient in most cases, not all cases. No method of dispute resolution is perfect. It's more efficient in most cases because the procedure can be designed by the parties in the arbitral tribunal based upon the specific needs of two parties or the various parties to an individual dispute, based on the specific characteristics of that dispute. Instead of taking a one-size-fits-all set of procedures off the shelf, so to speak, and imposing that on an individual case. One designs carefully procedures, tailor makes procedures for an individual case. That means that the proceedings are not just more efficient, cheaper for commercial parties, but also more expeditious. They can be quicker. In part, they can also be quicker because arbitration doesn't involve multiple layers of appellate review, always with the possibility that you will be returned back to the first instance court only to begin the entire process once more. Arbitration is, in a sense, one-stop shopping. You have your dispute resolved in a single proceeding, and that decision is final and binding. One realizes very substantial efficiencies because one doesn't have layers of appellate review. Arbitration is, I think, particularly efficient and expeditious in international cases because, in contrast to domestic disputes, international disputes can be, and very frequently, if the parties haven't agreed to arbitrate, litigated not just in one country's courts, but in 2 or 3 or 4 or 5 different countries' courts. The parties pay for the privilege not just of one set of lawyers in one country, but multiple sets of lawyers in different countries. Arbitration is more expert for some of the same reasons that it's more efficient and more expeditious. It's more expert because not only do you design the procedures for an individual case, but you also choose the arbitrators. That's the essence of arbitration. The parties choose the decision maker. They choose a non-governmental decision maker to resolve their dispute. And they choose the decision maker based upon his or her expertise in the subject matter. The parties know better than anyone else what their dispute concerns, what characteristics, capabilities are required to resolve it expertly, and they therefore have a strong incentive, the greatest incentive of anyone in the world, to choose someone who is truly expert, or a panel of decision makers who are truly expert. In contrast, a state court judge, in addition to being overworked, must decide cases involving administrative law, environmental regulations, tax disputes, employment disputes, everything in the world perhaps except the particular type of joint venture dispute or construction dispute that the parties' case in an individual arbitration actually involves. And thus, especially in an international context, parties can, if they have, let us say, an infrastructure project in the Middle East, choose an expert on both Middle Eastern law and infrastructure projects in that part of the world. That type of expertise is invaluable for commercial parties, but also for states when it comes to the resolution of their disputes. Arbitration is more even-handed, particularly in the international context, because instead of having a dispute resolved on one party's home turf, a dispute against a French company resolved before a French judge, one can have a dispute resolved in an independent, neutral, third country before an independent and impartial arbitral tribunal. In that sense, arbitration is more even-handed, more neutral and independent than litigation in each party's own home courts. Finally, arbitration is more enforceable. Arbitration, especially in the international context, produces a final and binding award with res judicata consequences, just like a national court judgment. Importantly, though, unlike a national court judgment, both international arbitral awards, but also arbitration agreements, are subject to the United Nations Convention for the Recognition and Enforcement of Foreign Arbitral Awards. The convention, with 159 contracting parties around the world, gives an enforceability premium for both international arbitration agreements as compared to other types of dispute resolution agreements, and arbitral awards as compared to national court judgments. That means when the parties agree to resolve their dispute in a particular way, that promise will actually be upheld under mandatory international rules in 159 states around the world. And when the arbitral process is finished, when an award is rendered by the tribunal resolving the parties' dispute, that award also can be recognized and enforced in those same number of countries. Those 5 E's are, in many ways, the pragmatic reasons that parties have chosen in an overwhelming majority of cases in recent decades to resolve disputes by international arbitration.